This podcast is sponsored by Quartz IP. For more than 20 years, the PracticeLink IP operations platform has helped some of the largest IP practices in the U.S. simplify and scale high-volume IP operations. PracticeLink is designed by IP teams for IP teams, bringing smart automation to mail intake, calendar management, and client communication while making sure service to your clients still feels personal. Learn how Quartz IP drives excellence in IP operations at quartzip.com.
Hello, everyone. Welcome to IPWatchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IPWatchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee, and welcome everyone to this week's edition of IPWatchdog Unleashed. Our conversation this week is going to be a panel conversation that we just had as a part of our AI Masters program. As in-house teams rethink how patent work is allocated, the implications for outside counsel are unavoidable. The traditional law firm model, which is built on labor-intensive workflows and leverage, is under increasing pressure as clients gain access to AI-enabled capabilities. We pick up our conversation with me introducing the topic. The future of patent law firms competing in an AI-driven market is the topic we're going to tackle here. We're going to talk about the supply side response. What is sustainable? What is the role of patent law firms in a market where clients are internalizing more, expecting greater efficiency, and some are explicitly demanding lower fees already because they just happen to know that AI is making all of us much cheaper, faster. We're not working as hard. All you patent lawyers and law firms are probably kicking up, drinking margaritas on the beach and letting your bots write everything for you anyway. I'm being facetious, but that is what some clients are saying. Not all clients are saying that. Most clients, I don't think, are yet. We'll talk about that. We'll kick that around with our panel. But Renee, let me kick it over to you to introduce our speakers.
Excellent. Thanks, Gene. Today on our panel, we have Carlo Cotrone. He's founder and principal consultant at Quartal IP, with more than 2 decades of experience across law firms and in-house IP leadership. He helps organizations strengthen IP strategy, leadership, and innovation management. Next, we have Robert Plotkin. He is co-founder of Blueshift IP and a patent attorney with more than 25 years of experience in software and AI. He is widely recognized as a thought leader in AI patent strategy. We also have Quinn. He's founder of IPWatchdog and one of the most influential voices in patent law and innovation policy. A patent attorney, he has spent decades shaping industry conversations around software patents and IP strategy. And last but not least, we have John Rogitz. He's managing attorney at Rogitz Associates, where he focuses on patent prosecution across AI, software, and advanced technologies. He also serves as an adjunct professor and legal industry leader in California and Florida. Back to you, Gene.
Great. Thanks a lot, Renee. And again, thank you for joining us. Let's just dive right in and get started with the panel's preliminary thoughts on this topic. I know that the panelists have heard a lot from their clients. They've heard a lot from prospective clients. So before we get into diving down deep and giving examples and talking about what we're hearing in the frustrations, big picture on AI and how it's affecting patent law firms. Carlo, maybe I'll start with you. I know you, for much of your career, have been in-house. Now you have a consulting firm that consults in-house attorneys and law firm attorneys, and you're kind of in that intersection trying to help them streamline, do better, and that sort of thing. So you see it from both perspectives, I'm sure. So what do you think about this issue?
Thanks, Gene. Yeah, what I would say is really this is a time where leadership as a practitioner, whether you're in-house or outside counsel, is really absolutely critical because right now there's such a disparate sort of representation of people who are really leading with AI or not, or understandably unsure of how to leverage AI to its utmost. A lot of people are trying things. Some of them are not working. Some are working. So I think it really, to succeed, you individually or in your team have to really step up and make up that difference and really from the law firm perspective in particular, really have client centricity, perhaps like never before. And then you can really help lead conversations, create dialogue, create a forum, a framework for actually succeeding together. But if you're waiting and waiting for your client to lead or vice versa, I think that's where a lot of the missteps and missed opportunities early on will happen.
So thanks for those thoughts, Carlo. John, let me go to you next. And, without necessarily having to get very specific off the top, what do you want people to have front of mind as we start this conversation?
Sure. Thanks for having me, Gene. I'd say two things to start. The first is there can be cost savings, but I think the real value is in the enhanced quality that AI provides. And I'm seeing that firsthand in my practice right now. It's enhancing the quality of my research, my writing, even the drawings that I generate before I hand them off to the draftsman. And so there could be cost savings, but I really think the real value in AI is the enhanced quality as far as the law firm goes. The second thing I would say, and I know we're going to get into this later, is that AI can actually be counterproductive. And so you really have to be careful about how you use it or really how you're using other people's AI outputs, whether that's an invention disclosure or even a review of a patent application. And like I said, I don't want to jump the gun too much, but I will say off the bat that ineffective use of AI can be very counterproductive. And so you really have to watch it.
Much more to be said there. But thanks, John. Robert, your initial thoughts on this topic.
I am on the one hand, a big proponent of AI because there are ways in which, when it's used responsibly, both by attorney and client, can be really powerful tool. What I've seen, I think, big picture, is that there is a lot of misunderstanding about what AI is and isn't good at and how to use it effectively. And when either or both parties have those misunderstandings, it can lead to problems, especially when one side overestimates its ability to do certain things, let's say, whether that be preparing a draft or reviewing attorney work. It creates miscommunications. And in particular, if both sides, attorney and client, aren't open with each other about how they're using AI, whether feedback was prepared by the client directly or using AI, it can lead to a whole host of miscommunications, inefficiencies, and problems. And I'd love to see more open discussion about that and education about what it is and isn't good at, and how both sides of the attorney-client relationship are making use of AI.
So let me start there and come right back to you again, Robert. For those people who don't know I've been a fan of yours since Genie and the Machine, which is a book that you wrote now. Hard to believe. It's over 15 years ago, I think, that you wrote that. And you've been doing AI and you do quantum computing. You're a very sophisticated mind in this space. So maybe we could probe a little bit about what is AI actually capable of doing? Because from my perspective, it seems to me, and everything that I've read and understand is that, and the way I say it is AI is not really intelligent. That's a misnomer, because AI that we have today is not actually programmed to get things right. It's programmed to sound like it got something right. It's a language model, right? So we're not at the point where this is this all-knowing Star Trek computer that's infallible. And I think people have that in their head that this is the Star Trek computer. What can you tell us about where we are in the evolution of AI? And it's not to say that these tools aren't great. I think they're fantastic, but I think knowing what they can and cannot do is sort of table stakes here.
I'll just say that, Ethan Mollick has used this term, the jagged frontier. I really like that because it's so hard to provide a concise description of what AI is and isn't good at, and its abilities, let's just stick with language models, are very jagged. There's certain things it does really well. There's certain things it does very poorly, and those things don't match up cleanly against what human skills typically are. In someone who's a good writer, they're often good across the board, whereas AI might be really good at some things and horrible at others. And even on the same problem, they might do really well one time and not another, or really well depending on how you prompt it. So that's the jaggedness. Just one aspect of the jaggedness, and it's not to dodge your question. It's to say that it's one reason why you really have to pay attention to how you use AI. Because if you think of it as if it were an intelligent, as you said, person, you're going to be misled. You're going to make assumptions that, oh, if I asked a person this kind of a question and it gave me this kind of an answer, I could rely on it in some way. But you really can't. What's the answer to that? Read up a lot about what other people have learned about what AI is and isn't good about, at, and then practice with it a lot and observe the results. And that's one reason I'll stop here why, honestly, I think AI is, in any field right now still, is best and most effectively used in the hands of experts in that field who have an ability to evaluate the outputs of it. Because if you are not an expert, its outputs, language models in particular, are so confident that unless you put a significant amount of external effort into validating the outputs, you're going to be very easily misled by.
So I want to throw something out there because you're hitting on this issue of consistency, which I think a lot of people don't really appreciate. There is something, and I've done a lot of research. I would love to, for example, be able to have a recurring comic strip related to IP. I have no drawing abilities, but AI can now create a one-off comic that looks fine, it looks good, and so forth. But if it's going to be a strip, you actually have to have the same character appear in each frame for every comic that you release, right? You can't even do that within a 3 or 4 frame comic strip right now today, and it's called character consistency is the problem. And when you're looking at this, you realize, okay, well, it got the character I have in mind exactly in the first panel, but by the last panel of the same strip, it's a different character, different person. It's drawing something totally different. Now you can see that and visually see the evolution. Now, what if you can't visually see that evolution, and it's not obvious because it's buried in a 50 or 100-page document, and there is that same drift, and it occurs in writing the same way it does in drawings, and that is a real problem. Now, the one thing, and John, maybe I'll ask you this, I know you've done AI as well, you've done work for video games, optics, and all that, fun stuff that we play with all the time is sort of where you've lived for a big portion of your career. And consistency really matters. And when you see something shift, it's obvious that it's shifting. Not so obvious when you're dealing with an invention that it's been shifting. And so, one, if you want to comment on that, and two, the thing I hear from patent attorneys all the time is, well, if I'm going to have to review it, then what's the point of having the AI do it? Now, I don't buy that so much because you'd presumably review a first-year associate's work or a patent agent's work anyway. But if you don't know what you're looking for and you don't know what the control is, that makes it a little tougher.
Yeah. I guess to address both your concerns in one, I would say for me personally, what I found is the incremental use of AI is much better than using a holistic approach. So I've talked about this before, and I was naive at first. I've been testing tools since they started coming out, the patent specific drafting tools. And I thought at first, naively, that I was going to give it a disclosure and it would just spit out a completely written draft. And that's just not the case, right? So it's better if you give it really targeted prompts, you incrementally build, you incrementally research, you do all those sorts of things, and then you still stay on target. And one of the best ways to stay on target is to merge the new with the old. And when I say that, I mean, you still have to do the old fashioned things. Interview the case with the inventor. Figure out straight from the inventor what's really important, right? Take AI out of it. And then if the inventor gives you AI outputs on top of it, or enhancements or whatever you want to call them, then use them as a complement. But again, I think this is something you could say about AI as a whole. It's a complement to the real work. It's not supposed to, be a replacement for that work. And so I think doing it that way, that approach really takes the drift out of the equation and really helps you stay on target.
Mhm. So, Carlo, how do you convey this to inside counsel? I mean, like, I know right now you're working with a bunch of law firms and trying to get them to understand their value proposition and how to communicate that and that sort of thing. But how do you capture this in a way that in-house counsel, who maybe you think it's a little bit further down the line than it is, more treat it more like a magic button? How can we convince them that it's really not quite that magic button that they want it to be?
Yeah, I think the reality is we're AI is reminding us that relationships really matter and really very white glove advocacy, solutions minded representation that goes to specific legal deliverables, but also something broader, the business, the operations. It really matters. And I was able to attend the last panel, and I was just really struck by the enlightened nature of those in-house practitioners, that I think many law firm practitioners would love to work for those clients, but that's not necessarily the standard for a lot of different reasons. So that's why I would say again, even though there can be a lot frustrations, and there have been frustrations on the law firm side really early on and continually, that's where the beauty of this is you can step forward and break this down and educate your individual client. And as we talked about in the pre-call, you can set up frameworks, you can pilot, you can set up fixed fee scopes that are AI scopes where you sort of have this journey together and you can learn together. And it kind of really, I think, as John was saying, then get the best of all worlds. But I think it really, if you have a client that is so dismissive of AI and everything, some of that may be cultural, it may be the leadership from the business side, but it may be also just the mindset of your client, and you, I think, have a problem long term if that's your client. But be that as it may, there's always, I think, the opportunity for you to lean into the relationships and try to be a true partner in its fullest extent, and then at least be able to navigate the darkness better than you would otherwise.
Navigate the darkness. I like that because it is to some extent. I don't know. You call it a dark side, but it's an unrealistic side. And we have somebody, James, in in the chat, just mentioned that it's not just in-house counsel who needs to, or I'm sorry, it's just not outside counsel who need to convince inside counsel. It's inside counsel who needs to convince their chief IP counsel and their CFO and their CEO that it's not a magic button. And maybe it rolls all the way back to there in the people just have a unrealistic view. Cause I was also, Carlos, struck by how reasonable in the last panel all the in-house counsel were. And these issues came up even this morning when we had another in-house counsel panel. And maybe it's just the nature of the people who would come and agree to speak on an artificial intelligence program like this, that they're more knowledgeable about artificial intelligence and they know where the potholes are. There's the old joke about, I think I could tell it because I am Catholic and I, believe in Jesus. So, Jesus just knew where the rocks were. He wasn't actually walking across the water, right? I mean, so in our space to kind of translate that is if you really are knowledgeable about AI, you know where the rocks are, you know where to step, you know where it's going to be secure when you step there, and you know when you are about to go face plant because there's no rock there and you're not going to be able to stand on top of the water based on what AI can do repeatedly. And I hope that didn't offend anybody, that analogy, but it was the best one I could come up with in the moment. Um, Robert, I see you shaking your head.
I just agree with you because I have clients who have been developing language model related technologies forever. And the ones I know who are the most sophisticated technologists are the ones who have the most realistic understanding of what AI can and can't do. They would never think of just letting it go loose. right? And doing an entire project. They understand its limitations better than anyone, but they also understand its power. And they've been trying to preach to the choir about that forever. So it is a situation where some balanced understanding is necessary, and yet it's a topic that tends to lead people to go to extremes, either to believe or expect that it's going to be a push button that you just press and it does everything for you, or that it's so horrible you should just avoid it. And yet navigating the rocks where you appreciate, understand how to leverage what it can do well, while understanding and learning how to navigate the potholes, I really like that analogy, is where you'll get the real benefit.
Yeah, and John, maybe I'll ask you to comment on this or anything that we've talked about here so far, but it feels to me like maybe it's just a human relationship issue or a humanity issue that if you really want something very badly, you really wish, you have a way of convincing yourself of things that just are not true or they're ahead of their time. And and maybe that's where we are with some of the clients at the moment. What do you think is going on in driving this? Because I suspect you probably had some clients that have said, like everybody, I want reduced fees, and then you got other clients that are a little bit more realistic, like Robert was just saying. So, have you got any insights into that?
Yeah, I think another way of putting it, Gene, is that people are just believing the hype. There's a lot that's written out there. There's a lot of hyperbolic statements on LinkedIn, you know, authoritative sources or presumably authoritative sources saying, if you don't do this now, you're going to get left behind and it can do all these things and blah, blah, blah. And you have futuristic articles being written, all of the above. And so it does change people's expectations a lot. And I think the best way to actually figure out where these tools are at right now is to use them. And so to continue with your stepping stone analogy, I would say, not only, figure out what AI is good at or not good at, but figure out what different models are good at. I was at a conference on Friday, and this was a big point of discussion. How there's people they're not just using one model. They figured out what Claude is better at as opposed to Chat and Gemini and all these things, and they're all different things. And so, if you do want to become a really sophisticated user, the best way to do it is to just start using them all and figure it out. And maybe you are going to spin your wheels a little bit at first, but the efficiencies will be realized later as you start to figure these things out. Now, another thing that I've seen, which I think is really neat, I haven't tested it. I know there's UIs coming out, that kind of allow you to interface with multiple models from the same prompt interface. And so you don't even have to click around and switch back and forth. Really soon, you're going to be able to just use whatever model you want with the touch of a button in the same interface, and it'll become much more seamless. But you still have to know what model's good at what.
Yeah, and I think you also need to know, and maybe with this we can kind of pivot this into the next phase of the conversation is how to get the AI model you're using to actually deliver things that are usable. So that, and because we can spend the whole rest of our time kicking around like unrealistic expectations and inside counsel and so forth. The truth is they are there. A lot of them have them, whether they are realistic or not. So then the next question is, how do you as a patent practitioner in a law firm outside deal with that in a way that allows you to not just have to work 26 hours a day in order to, do the billable work that you were doing for 12 hours or 10 hours or 8 hours a few years ago. So one of the questions I have is how do you use AI to make an application? Let's start there. Or if you want to take it from an office action response, because, and where I want to go with this is, are you better off asking for big, broad drafting, or are you better off asking for discrete little pieces and putting it together step by step? I think you're better off step by step. And then if it gives you something you don't like, I always ask it, well, what if it could do this, this, and this? How would you describe that? And really interrogate it, going back and forth, piece by piece by piece. Robert, I see you shaking your head.
Yeah, I am very much in favor of that. I know in a sense it's not that popular now in the sense that there's so much talk about movement towards agent-based systems that will handle all those steps. That's been for a few years, right? I am still a big proponent of the co-pilot model, which people would say that's very 2024, but it's still how I'm largely doing things. But it's also a mix. Let's say office action, right? I might use AI to help give me a summary of these references. I mean, this is something that we've done for hundreds of years. A patent application has an abstract on it. Why? Because it helps to orient you to the document before you read the whole thing. The AI can do that on its own, and they're usually pretty good. I mean, this is a general pointer. Use it. It often AI, because it's not completely accurate and it's statistical, it's really good at doing things where you don't need a completely accurate answer. And getting the gist of a document, which is often something we do in the process of writing a patent application or respond to an office action, is something you want. And the gist is really helpful to get quickly, even if it's only 95% accurate, because that orients you. It starts helping you brainstorm, and then you can do the kinds of things you mentioned. Come up with a strategy, ask a question about it, try it out, then maybe go ask, where might this be in the reference where I can go and read? So you're bouncing back and forth between doing things manually, reading a paragraph here or there, drafting claim language, and asking the AI either for suggestions, alternatives. And I think that kind of improvisational ability is something that's really helpful to develop. It's very much like working with a team of people in a room, if you ever have done that live, which many of us don't do, where you're bouncing ideas off. Different people have different skills, and you're working both at a high and a low level back and forth as you work through the process.
So, Carlo, let me ask you, are you seeing firms kind of restructure the way that they are doing the work, or maybe who does the work, or, staffing is changing, or let's start there. I mean, in terms of the work itself and the structure of it and how it's being accomplished and who's doing it, is that shifting?
I think we're seeing it selectively. I think there are some real first movers in the space who are really at the system level. They have a greater willingness to experiment and alters the architectures, so that's, I think, happening, but really in a minority of cases. And then we're seeing sort of everything between that and basically inaction. So I think the key really is, to the point of Robert and John, that something is being done that's proactive and thoughtful to see. And then, as we heard at the last panel or previous panels, I mean, some firms are and companies are bringing in AI experts, process experts, coding experts, really to help maximize the value of system redesign and execution. So those kind of strategies and tactics can be really, I think, very impactful. Versus in everything, all of this to me comes down to, I really worry about sort of the scarcity minded approach, the sort of defensive territorial approach that sort of says, yeah, we'll just wait and see. We're not going to do anything. I think that to me is really the danger here.
So the one question that I have here too is, it keeps coming up, that it's just understood, whether it's true or not, it's understood that there are efficiencies. It takes less time to do stuff, and therefore there will be cost reductions. The one question every time this comes up, invariably, I haven't seen anybody raise this yet here during this panel. They did earlier in the day. Who pays for the tool? And then who pays for the training? I mean, this is not a zero-sum game. This is like, if you want to be good at playing video games, John, maybe I'll come to you since I'm using a video game analogy. You want to be good at video games, you got to play the video game. You want to be good at golf, you got to golf. You don't just actually, sign up for a subscription at the country club and immediately, become a par golfer. You got to spend your time, and the same for video games and the same for AI. You don't just get a subscription from some of these tools or start weaving them together, say, you do this better, you do that better. I want to use both of you for different things. And then all of a sudden through osmosis, you're good at it. So what's the value proposition? What's the billing proposition? And if you haven't seen that yet, what do you think is going to happen? Where's it going to go? Is it going to be like we used to do? Well, I'll say me. I think I'm a little older than all of you, but when Westlaw and Lexis, you started using them, you would. This is how long I was on Westlaw. Here's the bill for how long I was on Westlaw for that length of time. The client paid it. Is that what we're going to be doing in this world?
I don't think so, at least not from what I've seen from my clients. The onus is sort of on law firms to learn how to use these tools. I mean, on the one hand, you're using Lexis and Westlaw for case-specific research, but here it's really just training. And I mean, in defense of in-house people, I don't know how you would rationalize that to the C-suite. Like, we're going to pay the law firms to train up their own people. It's not going to be matter specific. And whether it's right or wrong, I think that's probably the position they would take. I think as far as law firms go, there is a lot of learning on the fly to be done that if you're learning on a case specific matter, then maybe you can pass on to the client one way or the other. I still haven't seen any in-house people or businesses offer to pay for the subscriptions. They expect the savings, but they don't expect to pay for the subscriptions themselves. And then there's, of course, the deflationary pressure on fees in general because of that. And on that, I'm just not sure. I don't think a lot of the expectations are realistic, and I think that there's going to be a point if clients want to push the fees down that low, they're not going to get the quality that they want or they need. And so if you're going to ask law firms to train on their own and to pay for the subscriptions themselves, there's got to be a floor to the fees. And this goes back to what I said in my introductory comments, which is that I think this is really a driver of quality that more so than cost. And if you're going to put it all on the law firms, then that's probably how it's going to be.
Yeah, and there's one, maybe this is the time to raise this since we're talking about what this is doing to fees and who bears the burden or gets the benefit. You mentioned it, John, and we talked about it in some depth during our pre-call. These AI tools are creating more work for outside counsel than anything else. And I alluded to it, I think, already in this conversation that, we used to struggle to get more than 2 paragraphs. So you got 2 paragraphs of an invention disclosure, you were living high on the hog, and then you had to turn that into a 50, 100-page application, which I always wondered, well, who's the inventor in that situation? Was it the person who gave me the cryptic 1 paragraph, or is it me who wrote the 100-page application? And think we all know who was really the inventor in those cases, wink, wink, nod, nod. But now we've got a wholly other issue. In some respects, it's the same issue. In other respects, it's a different issue. We're not getting 1 or 2 paragraphs. We're getting 1 or 2 treatises in some, you're getting 50 plus pages of a disclosure, which is just gobbledygook. Number one, did the inventor really come up with that? Or did the inventor just put in the 1 or 2 paragraphs that they used to give us? And now that's the output from the AI, in which case now we got all kinds of inventorship questions that will probably not come up until the patent becomes valuable and litigated and then will be worthless for that reason. And then, number 2, even before you get to the inventorship issues and the patent not being valuable later on for or easily challengeable for those issues, you're going to wind up having a situation where now me as the outside counsel, I got to go through 50 pages to figure out what the invention is. I mean, that takes time. And then I want to talk about that too. And I want to put a pin in this as well to make sure we get back to it. Robert you had an interesting anecdote during the pre-call about getting AI feedback from the client, which also creates more work.
Yeah, I'll jump to that because I think let's take November 2022 as the start of all this when ChatGPT was launched, right? So we had people scrambling to figure out how to use it. Then we had attorneys starting to draft applications using it. Then we had clients generating the invention disclosures. And I think it's more recently, I've seen in the last year, a lot more client feedback on draft applications, office actions, appeal briefs, whatever work product I give to them. And there's a couple of problems with it. One, as you said, it can be extremely long. which then who is going to review it and how are you going to charge and how much are people going to pay for that review? Two, to various extents, disconnected from what I sent to the client, right? It used to be I send a Word document, I get back a marked up Word document or something with comments attached to a sentence that I wrote, which said change to the here. And it was obvious what feedback the client was giving me and what I should do. Now I send a draft and I get a separate AI generated feedback document. And it is unclear how that correlates to the draft I sent to the client. It raises the same question. Am I going to spend all the time to figure out how I need to revise the draft? And I've been having these conversations with clients actively about this issue. How are we going to deal with this particular? Is it an hourly engagement? And you're going to pay me by the hour to review this 50-page document? Are we going to void or adjust a fixed fee and do essentially a change order on a fixed fee? And for the anecdote you mentioned, I'll say it in an anonymized way. I had a client recently. I had filed several provisional patent applications for the client. Sua sponte, he sent me an email late at night saying, I had just done a review of all these patent applications you filed for me. And it was a large document reviewing the patent applications, clearly AI generated. And it included what I would call some scathing critiques of my work, including the phrase, the claims in some of these applications would pose an existential threat to the patent portfolio. I spoke to my partner. I contacted our malpractice care because I said, if this came from a human, I'd have to think there's a potential claim to be brought against me for doing such horrible work that it posed an existential threat to the patent portfolio. The last thing I'll say is I spoke to the client who said, oh, I didn't really mean that. That's not what I thought of your work. I'm extremely happy. So whether it's not knowing who the inventor is or not knowing whether the feedback you're getting is really the client's, all of these are a totally new situation in which we're getting communications from the client and there is some big disconnect between what they really think and what's being said in the document. That's the gap being created by AI, really, when it's generating stuff that is divorced from the thoughts or opinions or ideas of the human who put the prompt in. I'll just stop there.
Yeah, John, it looked like you wanted to jump in.
I think it can be worse than that, though, because if there is no disconnect and the inventor actually reads the AI output and that sets the expectations, that opens up a whole another can of worms, right? And bearing in mind AI hallucinates and is wrong all the time, that can really, really be a problem. So I have another anecdote for you. I had an inventor throw an AI output at me that said, you need to claim all of these things because if they're not in the claims as filed when the case is published, that subject matter that's disclosed but not claimed is relinquished to the public, which is just not even close to the truth, as I'm sure everyone on this call knows. But then, the inventors or maybe even in-house, if they don't know, or, maybe they're not IP counsel, but they're in-house, they're directing claim strategy based on that. And then what do you do? Because then you're basically arguing with the AI in front of the proverbial judge, right? This arbiter who's trying to decide who's right, you or the AI. And it can get really messy, And so with that case in particular, there was sophisticated IP counsel at that company. And I had to call and say, hey, number one, are you aware your inventor's doing this? And I hope your models are closed because the case hasn't been filed yet. But number two, I don't even know how to respond to these sorts of things and not make it even sound like I'm blowing the inventor off or that I'm saying too much. And I don't want to say too much in writing either. So you have to be really cognizant of these sorts of things and can really be counterproductive if the inventors aren't doing their part or they're just relying on AI. Now, I'll also say this. This is something else I raised in the pre-call. I get the impression, not on any good information, but I feel like a lot of inventors, when they're giving me an AI output that's reviewed what I've written, that they haven't read the case themselves. And that also creates a lot of problems because when you sign the declaration as an inventor, you have to say that what you're putting in there is your own invention and it's true and correct and all these sorts of things. And that's going to cause all kinds of problems if inventors are hitting the easy button and they're not taking the initiative to actually read what's being submitted. And then there's a trickle-on effect, a domino effect. I mean, all this stuff could come out in litigation or the patent's just not correct. It's technically inaccurate. That doesn't look good in front of a jury. There's all kinds of really bad consequences to that sort of practice. And so from a company perspective, you really have to be careful about how you're using AI to review things. And if you do have an obligation, which you do, to review things on your own as an inventor, then I'm not sure how much AI adds there in terms of value, unless you're just going to say, I want to say this, figure out a better way of saying it, right? Or give me something else to include. I need to tweak this. But to do sort of a wholesale review of the patent application with AI, it's not productive and it can lead to all kinds of downstream effects.
So, John, when you said that about you don't want to put this in writing, what went into my mind is obviously we all know why that is, right? We all in the industry, you don't want things that you've put in writing to come back to haunt the client later on. So you would pick up the phone and call. But at the same token, both you and Robert, you raise issues where you probably have to put something in writing for fear that it doesn't blow back on you. Because if somebody says, "Oh, it's matter of fact known, everybody knows if we file this claim, we'd lose all the embodiments that aren't claimed at the time of filing." I mean, okay, well, no, that's not actually how it works. And if you don't address that, that's the only thing that's in writing. I mean, looking backwards, nobody ever wants to have their files looked at. But if you look back on that and that goes unaddressed, that's probably not a great thing to have in your file unaddressed. And Robert, as you mentioned, you gotta, when they start throwing around existential threat or God forbid they use the word malpractice, or I'm going to sue you or whatever, you gotta take action there. And it's almost like this is creating the exact opposite of what it's intended to do, which is just more work. It's not creating less work. It's creating more work. I don't think it has to be that way. But Carlo, there's a lot on the table. I'd like to get before we branch off again, I'd like to get your take on any of these things we're kicking around at the moment.
Yeah, I think the way I would approach this or advise my law firm clients to approach this is essentially these are opportunities, these vexing existential dangers, frustrations, the character assassination of Robert, perhaps. I mean, these are really, I would say it's almost like it's highlighting system vulnerability or openings for you to essentially to get in trouble or just not be profitable. So I think as much as I would say don't be too reactive or reactionary, I think some of these anecdotes or others like them really will help you see, okay, I need to create a new special process or workflow or billing arrangement or something at least that's temporary that at least for the worst case kind of opportunities or dangers allow me to react to that. Some of it may be essentially also having extra conversations with clients or for AI cases, you have a 15-minute call with them and you highlight the things that can happen. And if you do not get useful inputs, this is what can happen. There'll be overcharges, whatever. But I think this is really actually useful because it sounds like this is not terribly disastrous at this point. But if you extrapolate it across your business as a firm for all your clients, I mean, there can be real system problems. So I think to me, I would approach it as an opportunity to again, like Gene said, the relationship. And it's tough right now, but getting in there in the ring and iteratively adapting to me, it's the opportunity to seize that. And then then you can relax things, tighten things, other things up later. But essentially you're gonna be able to evolve as the practice evolves, remain profitable, remain in compliance, or the perception of satisfaction.
Yeah, there's so much here. I think it's about relationships. You have to have these conversations. You have to let people know And there's a process in place, and the article I just wrote was about making sure you have something in your fee agreements to flag this as a potential issue, because flat fees do not envision getting a 50-page inventor disclosure. They do not envision getting 50-page report critiquing the application without red line suggestions. Flat fees do not envision the way that a lot of in-house counsel are starting to use AI and interact in this space or address the expectations. And there's a number of ways that this could be done, but I also think at some point in time that we as patent practitioners, you may need to say, sorry, I can't do that work for you anymore. Because if you're going to lose money doing it, you can't make it up in volume. If you're losing money with every transaction, that's just not a sustainable business. And the other thing I think that's important for the in-house counsel to understand, there's a reason most patent practitioners do not like working with independent inventors. One of the big reasons is because they're unrealistic and they're often, maybe most often, unsophisticated. And what I'm starting to hear is an awful lot of things coming from in-house counsel that sound unsophisticated and they just don't understand. And the same type of stuff that you get from independent inventors, who I can tell you, I've spent a large part of my early career working with independent inventors. You would give them a draft application, and the comments that sometimes would come back was, now this is an entirely new application on an entirely different invention. And it's like they've been continuing to work on it and didn't tell you along the way. They think the original search that you did, which related to nothing that they're working on right now, applies to everything they might ever work on. And they want you to add an additional 8 or 10 different embodiments into the application, as when you thought you were just going to get them to sign off and said, did I get it right? They come back with, no, this is going to require another 8, 10 hours or more worth of work. Flat fees don't envision that level of work. And I think in-house clients are at the risk, some of them, becoming that, for lack of a better way to say it, crazy independent inventor that you are allergic to working for. I understand that some people are going to lose money as practitioners in the short term. They're going to have to turn clients away that they maybe had never turned away before. But I think they're going to see opportunities in relationships where they can work with people that get it, that expand their business. And I look at all of this and I think, my God, the thing to get into is litigating right now, particularly in our space, because the mistakes that AI are going to make if you treat it like it's an easy button, the inventorship issues. And I understand that the patent office, just over the last couple of days, when I get into these program modes, I kind of get myopic and I kind of shut out what's going on around me. Somebody just sent me an email and said the patent office has recently sent out a reminder about what examiners do and what they're going to continue to do with respect to inventions using AI, not AI inventions, but inventions and descriptions that are written using AI, and how they're going to look at the embodiments and they're going to ask inventorship questions where they think it's necessary. So this is gonna blow up in the face of people who are treating this as an easy button. So you, as a patent law firm, I would caution you, this is not a race to the bottom. And if anybody wants a race to the bottom, let somebody else chase that to zero. I know that sounds crazy, but I think that that's the way you're going to have to do it. I mean, I'd like to get all of your thoughts. Carlo, maybe I'll start with you. I mean, you are the former client. Now you're consulting both sides. What do you think about this relationship and where it's going? And are some attorneys going to have to say no? And are some clients going to get shut out of competent representation?
Think that's likely, at least in some swaths of the practice. The last panel, Carl Prost, I loved his comment. He was talking about how AI magnifies the capabilities of people who are already in the room. And I think, to kind of take my darkness metaphor a little bit further, I feel like the room is kind of dimly lit right now, and pretty soon the dimmer switch will just keep getting raised, where sort of realities will come up, and ultimately will standardize on higher levels of expectation from both law firm practitioners and in-house counsel. So, and it will be, I think, fundamentally a value impact assessment. So, to me, really, the way this all settles out and gets solved is for both sides, relentless focus on value, creativity, using the tools maximally. And I think those who really take a step back and just try to really focus on costs or just turning the screws as tightly as possible and the race to the bottom. To me, that is just basically gonna crater eventually because operations that are focused on monetization, truly gaining assets that make a difference in the market, that's to me where the standard will be driven to. So I think the enlightened practitioner who focuses on value relationships, that's where to me success will be assured.
Robert, I see you shaking your head.
Yeah, I think it does. If we keep coming back to this issue of relationships, I hope there's enough clients, in-house attorneys, primarily, who continue to understand that and aren't led too far astray by the allure. It does remind me, for those of us who are around when the first big wave of outsourcing happened. I don't know, 25 years ago or something. There was a similar thing. There were a bunch of companies, particularly big patent filers, who said, hey, we'll just get the same number or more patent applications filed at a lot lower cost. And that worked for a while. And then some of those patents started getting litigated. And I know some people lost their heads over that after a while. But patents move slowly. It took 5 or 10 years before those patents got into court. So, I would hope people who have a longer term view can see that now and not, resist the allure of being dragged too far into the cost reduction or other promises, so to speak, of the technology. And at the same time, go back to what we said before. The technology has a lot of promise. I think it has a lot of value. It can do a lot of great things. The problem is when you just kind of open the gates and let it loose without internal training, policies, procedures at a company, without developing good skills and staying on top of it. That's really the problem, is going to an extreme.
Well, going back to your outsourcing comparison, a long time when that was a big issue, talked to a lot of in-house people, and I would ask them, like, how can you send your searches? And this was just about searching, this question, to India, for example. Most of the searching that I've ever seen done out of India, and this is not all of it, obviously, but the ones that I have personally seen have all been crap, various levels of bad. Why do you do that? Why? And the response came back to me is like, well, if I get a bad search, I'll just have them search it again. Okay, well, there's at least two problems with that. One is, how do you know it's a bad search? And if you knew it was a bad search, why were you doing a search in the first place? Because that would suggest to me, if you knew it was a bad search, that you knew something about this area, and maybe you shouldn't have been doing the search anyway. Maybe you didn't need to do the search, right? And then, so how did you know it was a bad search? And then number two, if they did a crap job the first time, why would you expect them to do a better job the second time? And so now, one thing with AI, searching is straight away in its wheelhouse. It does a really good job at searching in comparison, like, is this or that, or what's in this, show me where, those kinds of things it does. But it's the same kind of thing with the drafting, like, are you really going to know that embodiment doesn't work? And we've got some people in the chat talking about things that they're getting, and they look at it and it's like, you got this interesting invention, but it's got no power, no power source. I mean, sometimes it's clear that the AI has left something off. And sometimes it's not so clear that the AI has left something off, or that if you actually built it, it wouldn't work, and there's a lot of risk here. John, what are you seeing in that space, or, or any of it, with clients just being overly eager to use these things that maybe are not really working?
I think, to not to sharpshoot the oracle of patent law, as I like to call you, but I somewhat disagree with your framing earlier when you said, well, there's going to be people who are shut out of quality patent services or something to that effect, right? And the reason I disagree with that framing is because it's entirely voluntary. They're doing it on their own. So I think a lot of people on this call, like me, have probably had the experience where you have inventors come along and they have a provisional that they've already filed or drafted with the use of AI, and they just want to rent your license and touch it up. I think a lot of us don't have any problems saying no to that. But at that conference I just mentioned that I went to on Friday, and this was not in the context of IP specifically, what I heard in-house people say they do now is they, as in-house lawyers, begin the work product with AI and then hand it off to outside counsel to finish it up. And I don't know what you do there because you have to manage the relationship and you can't just say no if it's a big enough company and they're your existing client. But that's going to cause some problems. And I think there's going to have to be a big readjustment of expectations there.
Well, and there needs to be disclaimers, I think, in your representation agreements, right? Because we've talked about this during our pre-call, and I've started hearing people say that in-house counsel in some cases are drafting entire applications. Then they're sending it to you guys on the outside and saying, oh, spend an hour or two polishing this up and file it. Well, there's no way you can do that. I mean, not competently, not credibly, not ethically, probably, because that is just getting to the end and reading it is going to take a couple hours. And that's without knowing anything about the prior art. And that's without having any conversations with the inventor. Now, I can tell you if you've made some clearly egregious mistakes, used language I know the Federal Circuit doesn't like, left things out, added things that are more marketing or business related that is easy to just excise in that length of time, I can do that sort of, very basic fail-safe kind of triage for you, but I can't provide legal services on any level in a couple hours on an application like that. And so there is a lot of unrealistic expectations out there. And totally agree with you. This is self-inflicted. They're going to be pushed out of competent legal work by their own budgetary choices in a lot of cases. I think you're going to have to be unafraid to walk away from some work that is just going to present more risk, liability risk, malpractice risk than any kind of remuneration it may provide you. And, that's why we don't do work, quite frankly, with a lot of independent inventors, is because the risk is just goes way beyond any reward you could get. And I could see that there'll be some clients that are going to push that. But in the last minute or so we have here, I'd like to get each of you to give me your parting thoughts, your takeaway message. Carlo, we'll start with you. What is your message for the audience?
Again, as law firms focus really zealously on the client, those conversations, adapting the practice even in the darkness, and then for in-house practitioners, trying to get educated and try to be realistic and enter the journey with your outside counsel.
John, your final thought.
Definitely be realistic. And like I said, use AI as a way to drive quality, not lower cost. And the final thing I'll say, because we didn't get to touch on it too much, is that be wary of using AI to invent, because that is another area of the law where things aren't really settled. And to the extent they're settled, it's not in the applicant's favor. And so really, this is it's not a replacement for actual brain power. It's a supplement.
Yeah, we're going to have to change the way that people are thinking about AI inventing, but that's above our pay grade, unfortunately. Because if we don't adjust it, I really fear that there won't be any innovation on that level anymore, where that level of investment is required. Because if you can't protect it, you can't invest in it. And we're talking about billions of dollars to get some of these really creative solutions across the finish line in a whole host of industries. Used to just be pharmaceutical, but now, I mean, a whole host of different areas where hundreds of millions of dollars to billions of dollars need to be spent on the innovation and getting it all the way rolled out. And we've got to solve that problem. But thanks a lot, John. And Robert, the final word here in this hour goes to you. What say you for your message?
I'd say on the relationship issue, be prepared to have frank, sometimes difficult conversations with clients. I find it's been a good learning opportunity for me to learn how to re-express what value I bring and why coming to me as a patent attorney in the age of AI is extremely valuable still, and why maybe what the client is currently doing or proposing to do with AI on their side may not be the best thing for them even, and use it as an opportunity to educate them about how we can still best work together in the face of AI to produce the best output for them. But that really takes some thought, especially if you want to do it in a way that doesn't sound defensive.
Thank you for listening to IP Watchdog Unleashed. We will be back next week, and we hope you will join us again. In the meantime, please be sure to visit IPWatchdog.com to read all the latest news and information about what is happening in the intellectual property world. And also be sure to subscribe to our free daily email newsletter.